Welcome back to Good Law, Bad Law. On today's episode, we're talking about special prosecutors and prosecuting the president with my guest, Andrew Coan. He's a law professor at the University of Arizona Law School, and he's written a new book called Prosecuting the President. It's really a fascinating read, and this is really a fascinating conversation, too, about not only the history of special prosecutors all the way back to Ulysses S. Grant, believe it or not, but what are the roles? What is the role of the special prosecutor? What are the constitutional limitations on the special prosecutor? And what are some of the ways in which political pressure plays into this? And some of the important questions we need to understand about the current special prosecutor, Robert Mueller, and his investigation of President Trump. Can the president be forced to give testimony? Can the president, while sitting in office, be indicted, charged with a crime? These and many other really fascinating and important topics, and also what you, as an American citizen and a voter, need to understand about this important issue. All of that on today's episode. Stay tuned. Welcome back to Good Law, Bad Law. On this episode, we're going to be talking about special prosecutors. You know, ever since President Trump has been in office, almost the entire time of his presidency, he's been under investigation by what we call a special counsel, former FBI Director Robert Mueller. But to understand exactly how we came to the system we now have, where we have a special federal prosecutor who can investigate a United States president, a sitting president, to understand some of that background and to understand something about where this may be going, I've invited an expert on special prosecutors, Andrew Coan, the author of a new book called Prosecuting the President: How Special Prosecutors Hold Presidents Accountable and Protect the Rule of Law. So, first of all, Professor Coan, Andrew Coan, thank you so much for being on the program.
It's my pleasure. Thanks for having me, Aaron.
This is an especially timely topic, and one I've been very interested in most of my professional career. As most of our listeners know, I started as an investigative journalist in Washington in the 1980s, and I remember well one of the stories that I spent a lot of time covering was what we then called the independent counsel that was investigating allegations relating to the Iran-Contra scandal under the presidency of Ronald Reagan. And there have been special prosecutors since then, notably the special prosecutor that investigated President Bill Clinton, Kevin Starr, and others too that have been a little less well known. But there's actually a fascinating history to this, which you talk about in your book. And I want to start there with you and then work to the present with President Trump and special counsel Mueller. To do that, Andrew, I thought it'd be really helpful if you wouldn't mind giving us a bit of background on yourself, your background, and how you came to this topic and to the writing of this new book.
Sure. I am a professor of constitutional law and related subjects at the University of Arizona's James E. Rogers College of Law. I also direct a center on constitutional law here called the William H. Rehnquist Center, named for the late Chief Justice of the United States. And I have written and taught the constitutional questions, many of the constitutional questions that are raised by special prosecutor investigations for my entire academic career. Many of these questions are quite controversial, at least among constitutional scholars. But of course, special prosecutors have become much more salient since the election of President Trump in November 2016 than they have been at any point in the past 10 years. And that's when I started to get really interested in this topic. And I began to think about writing a book because everybody that I knew, and many people that I didn't know, people I sat next to on planes or on the subway, seemed to be desperate to understand how special prosecutors work. assumed that someone would have written a book about this already, and there are a few books out there addressing particular special prosecutor investigations, like the Iran-Contra investigation that you mentioned, and Watergate and the Bill Clinton investigation. But nobody had written a book about special prosecutors as a kind of institution, explaining how these officials came to exist in the first place, and what powers they exercise and what special challenges they face, at least not for a general audience. So I decided that I would do it myself.
Well, let's start with the basic structural challenge that we face in our constitutional system, because we have an executive branch that's charged with enforcing the laws, the federal laws of our country, and fanning out across the country federal prosecutors who work in varying United States attorneys' offices whose job it is to do just that. But we have a special structural problem and a constitutional problem to wrestle with when it comes to crimes or potential crimes committed by members of that executive branch on up to the president. So why don't you just lay out for us what that structural problem is before we get to some of the history behind all of this?
Sure. As you mentioned, the president is the nation's chief law enforcement officer. He exercises that power under Article 2 of the United States Constitution, which vests what the Constitution calls the executive power of the United States, the power to implement and enforce the laws, in a single president of the United States. And to help him do that job, the president has the power to appoint an attorney general who manages the Department of Justice on a day-to-day basis. But when it is the president and his close friends and associates, maybe his family members, as in the present case, who are credibly accused of a crime, we have a problem. It's a classic case of the fox guarding the henhouse, or a man, in this case Donald Trump, being asked to be or to serve as a judge in his own case. So I think of the book as a kind of a mystery story. The president, as the nation's chief law enforcement officer, has the power to fire a special prosecutor, in this case Robert Mueller, at any time. And yet, presidents live in fear of special prosecutors. The Watergate special prosecutors actually drove Richard Nixon from office, and Robert Mueller has managed to hang around for almost 2 years now, despite the President of the United States clearly wanting to shut down his investigation and having the power to do it at any time. So how can this be? How can special prosecutors simultaneously serve at the pleasure of the President, be so vulnerable to presidential control and presidential oversight, and at the same time exercise meaningful power to hold the President accountable? And the short answer is that special prosecutors serve as catalysts for democracy. Their high visibility in the media makes it easier for the American people to monitor presidential misconduct and then to hold the president accountable for his actions.
And by the way, we should be clear, it's not only the president, right? There have been special prosecutors, sometimes depending on the law governing them, they've been called independent counsel, or as they're now called special counsel, that have investigated allegations of wrongdoing against members of the president's cabinet or other senior executive branch officials, right?
That's right. Special prosecutors have historically been used to investigate a wide variety of allegations involving both the president and persons so close to the president that the president's hand-picked attorney general just could not conduct a credibly independent or impartial investigation.
So, I mean, it was fascinating as reading the book to learn, because it's really in the modern era, starting at least in my consciousness with Watergate. I mean, I was a teenager in the 70s, and I think it was really through the experience of living through Watergate that got me interested in journalism and ultimately interested in law. And of course, that history probably for many Americans at this point seems like ancient history, but it really is modern history, Watergate, and then the Reagan years, and then the Clinton years leading to Clinton's impeachment, stopping just short of his being removed from office, and now the independent counsel or special counsel that dominates much of the news during President Trump's administration. But it was fascinating to read some of the stories of special prosecutors back to history, going all the way back to the first special counsel, which involved President Ulysses S. Grant. So I'd love it if you'd give us maybe just some of the more colorful stories involving special counsel back in the olden days, and in particular how those early experiences illustrated the problems that we face when we have a high-ranking executive branch official or even the president involved in allegations of criminal wrongdoing.
Sure. I think it's very important for people to understand, and that many people don't understand, that special prosecutors are not a modern invention. We see them only periodically, so it's easy to forget the past cases in which special prosecutors have played an important role. But they're not a modern innovation. They're not a partisan tool of Democrats. For 140 years, dating back to the administration of Ulysses S. Grant, presidents of both parties have appointed special prosecutors, and they've done so mostly to neutralize political scandals and as a way of publicly signaling their commitment to the rule of law and their confidence in their own innocence. So presidents have a political incentive, a powerful political incentive, when credible allegations are raised that they or their close advisors have been involved in criminal wrongdoing, to send a signal to the public that no, despite the smoke suggesting the possible existence of wrongdoing, they actually have not done anything wrong, not done anything that would warrant public censure or any kind of negative reaction from the voters at the ballot box. And one way to do this, in a way that ultimately caught on after Ulysses S. Grant tried it for the first time in 1875, is to point an outside prosecutor, someone from outside the government who's independent of the normal hierarchy of the Department of Justice and who operates outside the day-to-day supervision of the president and the president's handpicked attorney general. The Grant case is a really good example of this. It arose from a scandal known as the St. Louis whiskey ring. And to understand how this scandal worked and how the president became embroiled in it, it's first important to understand that one of the major sources of federal revenue in the 19th century was a tax on whiskey, which was collected by local federal revenue agents who were appointed as part of a political patronage system. And it was an environment that was really ripe for corruption and ultimately rife with corruption. And several members of Ulysses S. Grant's administration became involved with, or at least were alleged to be involved with, a scheme to basically cooperate with whiskey distilleries to underreport their production of whiskey, thus reducing their tax liability. And then Grant's subordinates in the St. Louis Revenue Office and some members of his close administrative staff would split the proceeds, split the tax savings with the whiskey distillery. So it's a basic, really
a bribe
kickback scheme.
Yeah.
And President Grant's favorite protege, what was then called his personal secretary, what would today be called his chief of staff, Orville Babcock, who had served on Grant's staff in the Civil War, was actually heavily involved in this scheme and came under extensive public suspicion when Grant's Secretary of the Treasury, Benjamin Bristow, discovered evidence that Babcock had been conspiring with these federal revenue agents in St. Louis to skim off federal revenues and to enrich himself. So, given Grant's close relationship with Babcock and several of the other alleged conspirators, it was just not possible for Grant's Attorney General to conduct a credibly independent or impartial investigation, and to dispel the cloud of suspicion that had come to rest over his administration, Grant decided to appoint the nation's first independent or special prosecutor, a man named John Henderson, who was a former U.S. Senator from Missouri, who in fact cast the deciding vote against the impeachment of Grant's much reviled predecessor, Andrew Johnson, and had a real reputation for political independence, for a kind of rock-ribbed political independence. And this historically has been the profile that special prosecutors fit. They're chosen for their reputation for integrity, their reputation for political independence, because that allows presidents to signal to the public that they have nothing to hide and that they're committed to the rule of law and to conducting an independent and thorough investigation.
So how did Grant even come up with this? I mean, because now we have special counsel laws and elaborate Justice Department regulations that apply to special counsels, what they do, how they report, how they set up their offices, in great detail. But I don't think we had that back in the 1870s, right? So how did they even come up with this idea?
Well, I wish that I could give you a precise explanation. Unfortunately, the historical record is extremely sparse on this question. You're right that there was no elaborate system of regulations requiring the president or authorizing the Attorney General to appoint an outside prosecutor to investigate the St. Louis whiskey ring. Nothing like that existed at the time, and in fact, that exists today partly as a product of Grant's appointment of John Henderson, as well as many other president's decisions to appoint special prosecutors over the years. But this much is clear. The Justice Department was facing allegations of improprieties or having close ties to several of the key members or the key alleged members of the St. Louis whiskey ring. And there was a widespread public perception that the Grant administration could not be trusted to investigate itself. And Grant responded to this in the first instance by relieving the U.S. attorney, the sitting U.S. attorney for the District of St. Louis, of his job because he was alleged to have close ties to the head of the St. Louis whiskey ring, and replacing him with what he hoped would be a more credible figure. And then through his conversations with the new U.S. attorney, at some point Grant decided that the only way to really address these perception problems and this perception of a conflict of interest between the Justice Department and this particular investigation was to appoint someone from the outside, and that's when he appointed John Henderson.
Well, and you mentioned the political element in this, when you have a public scandal involving the president or high-ranking officials in the executive branch. And you used a very important phrase earlier that I wanted to just explore a minute because, and that was this idea of the rule of law. And that becomes really important, I think, in these types of investigations. But President Grant was known for being a very upright person, morally and ethically. He'd been this great Civil War general and had that reputation. So, how does that play into this whole Grant story? Because I think that becomes a theme that carries through to the modern era. This idea that what's really important in how these investigations get handled is this notion of the rule of law. What does that even mean?
Well, the rule of law is a famously malleable phrase, and it can mean a lot of different things in a lot of different contexts, and to some extent it means different things to different people. In this context, it is really a shorthand for the idea that even the highest government officials, even the President of the United States, don't exercise unlimited authority. In fact, they exercise authority only in the name of the people, and they exercise authority subject to legal constraints. More than 200 years ago, and when President Grant appointed the first special prosecutor about 100 years ago, the American people had fought a revolution to overthrow the maxim that the king can do no wrong. And in its place, they enshrined the fundamental principle that no one, not even the president, is above the law. And so when I say the rule of law, it's really as a shorthand for that ideal. And there are really few ideals which have played, few principles which have played a more central role in the nation's democratic self-image over time. And it was Grant's desire to signal his commitment to that idea, which I think inspired him to appoint John Henderson as a special prosecutor, and later presidents to appoint special prosecutors of their own. And, you know, you can argue or you can debate in any individual case whether the president is sincerely committed to the ideal or whether the president just feels public pressure to signal his commitment to the ideal. But in the end, I think it amounts to the same thing. In the context of the American democratic system historically, the president has faced strong pressure to live up to that principle and to signal to the public that he intends to live up to that principle.
Well, right, and you hear that criticism of President Trump a lot. I'm thinking of some of his more higher profile critics, for instance, George Conway, the husband of Kellyanne Conway, one of the top advisors to President Trump, who, while still married to Kellyanne Conway, has taken to Twitter and to the cable news shows as a dissenter and a critic of President Trump. And one of the things that he says a lot about what disturbs him in what he sees going on, and this is a man who's been a lifelong Republican, and in fact who was one of the lawyers behind the scenes who worked on the team of lawyers for Paula Jones and helped get President Clinton impeached. So this is somebody who knows about high stakes executive branch alleged wrongdoing. And his criticism is, as he frequently says it, his concern that President Trump exhibits behavior that is against this idea of the rule of law, that even the president is not above the law. So how does this idea of there being a special counsel, do you think, stand for that idea and really work to reinforce that core principle in the way our democracy is supposed to function?
Well, I think you highlight a really important point, which is that at any given time, it is easy to see special prosecutors, and for that matter, the rule of law and the principle that the president isn't above the law, through a partisan lens. So Robert Mueller's investigation threatens President Trump, which Republicans don't like. And it's easy for any given Republican to jump to the conclusion that the special prosecutor is just a tool of Democrats and to jump to the president's defense reflexively or instinctively. But the special prosecutor as an institution and the rule of law as an ideal, both of them are nonpartisan. And I really think that all Americans have a profound interest in preserving those principles. But the principle can survive only if the American people are capable of setting aside partisanship and supporting presidential accountability, even when a president of their own party is credibly accused of breaking the law. And at the end of the day, this is what gives special prosecutors their strength, but it's also special prosecutors' greatest weakness. They really depend on public support. They depend on the willingness of at least some fraction of the American people to set aside their partisan commitments and to say, okay, there are credible allegations of wrongdoing on the table against the president or his high-level associates, and we're going to demand a special investigation. We're going to demand an outside, impartial investigation. We're going to hold the president accountable if he refuses to provide one. But at the end of the day, it really is up to the American people. Special prosecutors cannot save us from ourselves.
Right, and this idea that, the special prosecutor depends on the faith and confidence ultimately that the American people have in that person or that members of Congress acting on behalf of the American people have in that person. On the one hand, and on the other hand, the frequent way that the subjects of the special prosecutor's investigations, namely the president, often strike back is to make partisan or political arguments, to say that they are politically motivated. That's something we've seen in almost every high-profile special counsel investigation. The people who were supporters of Bill Clinton made those same types of criticisms of Ken Starr, and maybe they were founded or not so well founded then. But that's something that has been part of the nature of these special prosecutor investigations all along, hasn't it?
It has, and it goes all the way back to Ulysses Grant and the special prosecutor investigation conducted by John Henderson of the St. Louis whiskey ring scandal, which was subject to ferocious attacks by Grant's partisan Republican allies, many of those attacks orchestrated by Orville Babcock himself, Grant's chief of staff, who was under investigation as a central member of the whiskey ring conspiracy. And it's important to point out that sometimes these attacks have a basis in fact. It's true that special prosecutors are entrusted with substantial authority and they can abuse their power or lose their sense of proportion. I think it's fair to say that by the end of his investigation, Ken Starr had come to resemble Captain Ahab from Moby Dick, just determined to bring down the president at any price, or at least monomaniacally focused on that objective in a way that distorted his otherwise sound judgment, or what might have been his otherwise sound judgment. But the truth, and this is also important to keep in mind, is that historically most special prosecutors have behaved ethically and responsibly. Most special prosecutor investigations, in fact, have ended without any indictments. And the popular image of a runaway special prosecutor that presidents have so frequently invoked, President Trump, of course, loves to use the phrase witch hunt. He describes Robert Mueller's investigation as the greatest witch hunt in American history. President Clinton's criticisms of Ken Starr, the criticisms leveled at Ken Starr by President Clinton's political allies and surrogates were a little bit more refined, but
it was the same general idea.
Yeah, it was the same general idea.
Right.
But these have largely, this idea, this image of a runaway special prosecutor, has largely been a tool historically of presidential propaganda.
Mm-hmm. But even so, as we've gone through the more recent history from Watergate, when President Nixon famously, in what's become known as the Saturday Night Massacre, fired the special prosecutor Archibald Cox, which did not do President Nixon any favors politically, of course. Through Clinton's experiences with Ken Starr, the issue of how to balance these different concerns to, on the one hand, maintain a sense of independence, an actual independence on the part of the special counsel, without giving the special counsel so much independence that they can have the potential to run away with their investigations or broaden the scope of what they're looking into beyond, what's reasonable. How have we, in the current model that exists now and that governs the current investigation being run by Robert Mueller, how have those different interests and needs been balanced to try to reach a better balancing of those different factors?
Right. So I think to understand what we mean by better balancing of the need for independence on the part of the prosecutor on one hand and the need for accountability on the part of the prosecutor on the other hand, it's important to start with a little bit of historical background, in particular with the independent counsel system that was established after Watergate. So historically, presidents were under no legal obligation. In fact, there was no formal regulatory framework in place at all governing either the appointment of a special prosecutor or the conduct of a special prosecutor investigation. After Watergate, there was a widespread public perception that this gave the president too much power to either refuse to initiate an independent investigation or to interfere with such an investigation once it had already been begun. And so Congress passed something called the Ethics in Government Act of 1978, which established a much more powerfully independent special prosecutor than had historically existed in the United States. That was referred to as an independent counsel, a term that you've used a couple of times here this morning. And the independent counsel established by the Ethics in Government Act existed for 20 years, roughly, from 1978 to 1998. Ken Starr, who investigated Bill Clinton, was an independent counsel appointed under this statutory regime. And the key difference between independent counsels appointed under the Ethics in Government Act and special prosecutors appointed prior to the Act was that they could only be removed by a president for good cause. Historically, special prosecutors had served purely at the pleasure of the president, meaning they could be removed for any reason. But under the Ethics in Government Act, the president had to come up with a good reason for removing the special prosecutor. It was formerly the Attorney General who had the power to remove the special prosecutor, but because the president can remove the Attorney General at any time for any reason, in effect, the president had the power under the Ethics in Government Act to remove a special prosecutor, but only for a good reason. And if the special prosecutor thought that he had been removed or she had been removed for a bad reason or for no reason at all, for an improperly political reason, she could seek judicial review of the president's decision, and the courts could set that decision aside. So that was the system that gave us Ken Starr, and there was a widespread perception after the Ken Starr investigation, and frankly after the Iran-Contra investigation. This was a bipartisan perception that independent counsels had too much power. They were not sufficiently accountable, and that the difficulty of getting rid of an independent prosecutor basically gave the independent prosecutor, the independent counsel, a kind of unlimited power, made the independent counsel sort of unaccountable, headless branch of government unto itself. And so in 1998, Congress allowed the Ethics in Government Act to lapse. As it was originally written, the act had to be reauthorized every 5 years. And ever since then, the question about whether a special prosecutor is appointed and the powers exercised by a special prosecutor has been governed by a set of regulations drafted by senior lawyers in President Clinton's Justice Department, most notably former acting Solicitor General Neil Katyal, who ran the task force addressing these questions. And these regulations attempt to strike a new balance, one which establishes a meaningful measure of independence for the special counsel, which is the name that the new regulations use for special prosecutors, but also maintains a high degree of accountability by giving the president and the attorney general more power to supervise the special counsel's investigation and more power to remove the independent counsel if the president or the attorney general believes that the special counsel has suffered a lapse of judgment or has otherwise abused his or her power. So you might think that the system leaves the special counsel, in this case Robert Mueller, very much at the president's mercy, and formally it largely does, because the new regulations basically give the president the final say, the final decision about whether there is good cause for removing a special prosecutor. But the flip side of that is that the regulations, in effect, put the president on the public record and the attorney general on the public record as saying, we are committed to appointing a special counsel when we genuinely need an outside investigator, and we are committed to not firing that outside investigator, that special counsel, unless there really is good reason. And so there is a kind of political check that operates to protect the special counsel, and which has effectively operated to check President Trump from firing Robert Mueller for roughly 2 years now, or going on 2 years now, despite his obvious interest in doing so.
Well, we've heard reports that Congress wants to pass some kind of a law to protect the special counsel, to protect this special counsel, Robert Mueller, to make it less likely that the president would interfere by firing him. What is that? What could Congress actually do to protect the special counsel? How would that work?
There has been a lot of discussion about this, and I think at least on the Democratic side of the aisle, there has been some rethinking of the conventional wisdom that developed in the aftermath of Bill Clinton's impeachment. As of 2000, when the new special counsel regulations were drafted, both Democrats and Republicans agreed that the Ethics in Government Act was a bad idea, that a special prosecutor who enjoyed statutory protection, tenure protection, and could only be fired for good cause and could seek judicial review of that determination, created a kind of monster, a special prosecutor who was capable of and had the incentives to abuse his power and to lose his sense of proportion. So there was broad agreement as of 2000 that the decision about whether to fire a special prosecutor ought to rest solely within the executive branch and should not be subject to congressional interference or judicial oversight. So a lot of Democrats and some Republicans seem to be having second thoughts about that in light of the persistent threats that President Trump has leveled against Robert Mueller's investigation. And there are a variety of legislative proposals on the table. All of them involve a restoration of the statutory protection that special prosecutors enjoyed under the Ethics in Government Act. In effect, they would prohibit the President or the Attorney General from firing Robert Mueller or another special prosecutor, except for good cause, which is a higher standard than it sounds like. It's a kind of legal term of art, which basically means that the President will be prohibited from firing Mueller except for a really good reason. And they also would permit Mueller to seek judicial review of any decision by the President or the Attorney General terminating his investigation.
So it does seem like the pendulum shifts back and forth depending on the circumstances. And, I think I just want to make sure this point is clear because I think it is important to the idea of the independence of the special counsel that, and I've heard Neil Katyal talk about his involvement in writing these regulations. You mentioned it was done under the auspices of the Clinton Justice Department, but it's my understanding, I do think you talk about this in your book as well, that when Neil Katyal's task force was looking to rewrite these regulations and give some definition and structure to the special counsel investigations, it wasn't just something Democrats were working on. There was a lot of consultation with between Democrats and Republicans because, after all, Republicans really hated what independent counsel Walsh did to Ronald Reagan and George H.W. Bush in the Iran-Contra investigation, and Democrats were still licking their wounds from the Ken Starr investigation. So both political parties had an interest in trying to strike this balance, and here we are again, still wrestling with how to reach a good balance between independence and, as you put it, accountability.
That's exactly right. And I think there is a real tendency to fight the last war every time this issue comes up. When Katyal's task force drafted the current regulations back in 2000, as you mentioned, with a lot of consultation with Congress, as well as various senior lawyers within the Justice Department at that time.
Including Ken Starr himself, right? I think you mentioned this, that Ken Starr was involved in arguing for more limitations on the independent counsel after he was all done.
That's right. As far as I understand it, he wasn't directly involved in crafting the new regulations, but he did testify before Congress opposing the renewal of the Ethics in Government Act on the ground that it gave independent counsels too much power. And I think that in 2000, the most salient examples of independent counsel investigations, although they were by no means the only ones, but the most salient examples of independent counsel investigations on everyone's mind were the Ken Starr investigation of Whitewater and the Monica Lewinsky affair, and Lawrence Walsh's investigation of the Iran-Contra scandal. And as you mentioned, Republicans thought that Lawrence Walsh's investigation had gone off the rails. It lasted for 7 years. And Democrats clearly thought that Ken Starr had abused his powers as independent counsel. And so there was a lot of skepticism based on a bipartisan perception and these highly salient examples of cases, which both parties didn't like, about the dangers of special prosecutors. And of course, depending on your perspective, both of these cases illustrate that there is potential for a powerful independent prosecutor to lose his sense of proportion and to abuse her power. But there's another set of dangers, which were illustrated by the Watergate case, the case that gave rise to the Ethics in Government Act and the creation of a powerful independent special prosecutor in the first case. And those dangers involve the president improperly interfering with what should be an independent investigation, the president, in effect, acting as a fox guarding the henhouse. And the dangers posed by the president serving that role, acting as a judge in his own case, and overseeing an investigation into himself and his high-level advisors and associates, I think had been obscured to some extent back in 2000 when the new regulations were written, because there were more recent examples on people's minds, the Clinton investigation and the Iran-Contra investigation. Well, now we have another example on our mind, the Trump-Russia investigation, and I think people have begun to worry, certainly Democrats have begun to worry more about the risk that the president will improperly interfere or even try to shut down an independent investigation into himself and his advisors. And some Republicans seem to share this concern, and the current proposals to create a statutory special prosecutor who could not be fired by the president without judicial review enjoys some bipartisan support, I think, for this reason.
Okay. All right. Now, Andrew, I'm going to complicate things even further because we now understand the background and some of the complexities involving these special prosecutors. But with this president, it does feel like it's an unprecedented number of investigations of varying issues involving a president. But we have other kinds of investigations going on that don't necessarily involve special prosecutors. There is a court case in federal court in Maryland that was brought by a public interest group that is trying to pursue claims that President Trump violated the emoluments clause of the Constitution by having foreign governments direct money to hotels and properties owned by the president. He still owns them in his role as a private businessman. That doesn't involve a special counsel, and a federal judge in Maryland recently authorized the parties to engage in discovery, which means that they're going to be able to start issuing subpoenas to ask for documents relating to, for instance, entourages from Saudi Arabia deciding to stay at Trump's hotel in downtown Washington, D.C. And then we have a not special prosecutor, the regular United States attorneys in the Southern District of New York, who have already obtained a guilty plea involving the president's former personal lawyer, Michael Cohen, for, among other things, violations of election law, federal election law, and the payment of hush money payments to a couple of women that allegedly President Trump had affairs with, before he became president. And it's widely understood that the unindicted co-conspirator in that whole set of circumstances is the president. So how do these all, how do these come together? Those are not special counsel investigations. Why? I guess first of all, why aren't they?
Let me distinguish between the two cases. The first case that you mentioned which involves a challenge to President Trump's ongoing involvement with his family business, and an argument that his ongoing involvement with that business violates something called the Emoluments Clause of the Constitution, which prohibits the president from taking gifts or other financial benefits from foreign nations. That's a civil case brought by private parties against the president, and it's not the kind of case for which a special prosecutor has historically been appointed, although some kind of independent internal government investigation could certainly be, you could imagine such an investigation being conducted of this same set of issues. The second example is really, I think, the more pertinent and really quite an interesting one for given the question that you posed, which is why don't we have a special prosecutor investigating the campaign finance allegations against Michael Coan, who, after all, was the president's personal lawyer. That's a pretty close personal relationship. It's not entirely clear that you could trust the president's hand-picked attorney general to conduct a fair and impartial investigation of the president's own personal attorney, especially when that investigation turns up evidence that the president himself may have been a co-conspirator in that attorney's criminal activity. And so this is clearly a case of the kind for which special prosecutors historically have been appointed. And I think you could make a strong argument that the case for appointing a special prosecutor to investigate the campaign finance allegations to which Michael Coan pled guilty and the campaign finance conspiracy in which Michael Coan implicated the president is at least as strong as the case for appointing a special prosecutor to investigate collusion between the president's 2016 campaign and the Russian government. Why haven't we actually seen that happen in this case? I think the reason is largely political. After the appointment of Robert Mueller to investigate the Russia questions, President Trump made extraordinarily clear his displeasure with that decision, made it especially clear to his then Attorney General, Jeff Sessions, and ultimately seems to have relieved Jeff Sessions of his responsibilities, forced his resignation as Attorney General, in large part because of his displeasure with Sessions' willingness to allow the appointment of a special counsel when he could have prevented it. Well, Acting Attorney General Matthew Whitaker was at the Justice Department for most of these events. He's had a front row seat watching and observing the president's displeasure with the way that Jeff Sessions handled the Mueller investigation. And so I think it's pretty hard to imagine an acting attorney general like Matthew Whitaker, appointed probably because, more than anything else, the president was confident of his political loyalties, taking a step that would displease the president as much as the appointment of a special counsel would displease President Trump in this case. But I think this case is also a nice illustration of the dangers of not appointing a special counsel to conduct an investigation that does directly, personally implicate the president. There were widespread press reports a couple of weeks ago that after the Michael Coan's guilty plea and the Department of Justice's sentencing memo filed in that case, which directly implicated President Trump in a conspiracy to violate federal campaign finance laws, that Trump called Matthew Whitaker basically onto the carpet and expressed his displeasure with the actions of the U.S. Attorney's Office for the District of New York in pursuing this investigation into Michael Coan and for filing a sentencing memo that seemed to implicate him directly in federal campaign finance violations. And that's exactly the kind of presidential interference that special prosecutors are supposed to prevent. If Robert Mueller had been running that investigation or some other independent prosecutor had been running that investigation, it would have been harder, not impossible, but much harder for President Trump to actively interfere in the way that he seems to have been trying to interfere with the investigation of the U.S. Attorney's Office for the Southern District of New York. Something like this, very like this, happened at the early stages of the Watergate investigation, which began as an investigation by the U.S. Attorney's Office for the District of Columbia. Those U.S. attorneys in D.C. who were conducting the Watergate investigation, who uncovered the conspiracy to cover up the Watergate burglary among Nixon's senior campaign staff and White House advisors, reported their findings up the chain of command to Henry Peterson, who was, I believe, the Deputy Attorney General, maybe the Assistant Attorney General for the Criminal Division at that time. And Peterson shared those findings with the White House, a really damaging breach of confidentiality at a crucial stage of the investigation. We don't know exactly what information Matthew Whitaker may have shared with the Trump administration about the ongoing investigation in the Southern District of New York, but it's this, exactly this sort of interference, exactly this sort of conflict of interest, and appearance, at a minimum, appearance of impropriety that comes with the president supervising an investigation into himself and his close associates, or the president's attorney general supervising an investigation that special prosecutors are supposed to avoid or supposed to counteract.
So in other words, those regular prosecutors, federal prosecutors in New York, who indicted and then secured a guilty plea from Michael Cohen, and the testimony from Cohen that President Trump directed Cohen to engage in those activities, they report to up the chain of command in the Justice Department all the way to the Attorney General, now an acting Attorney General, and that individual reports to the president. So in that structure, there really wouldn't be anything to prevent communication about what's going on, what decisions should be made, what next steps to take, and so on. In the ordinary chain of command, so to speak, and that's really why there needs to be an apparatus to have a special counsel in the first place.
That's right. Although I should add one caveat, which is that the U.S. Attorney's Office for the Southern District of New York, from all appearances, has conducted itself with great integrity and has shown great courage. The lawyers at that office, including the political appointee running that office, the U.S. Attorney for the District of New York, who was appointed by President Trump himself, have shown great courage and fortitude and integrity in pursuing these allegations against Michael Cohen, even to the point of directly implicating the president. And their commitment to doing so, I think, is not an accident, and it's not simply a product of personal virtue, although it probably is a product of that in part. It's also a product of strong internal norms within the Justice Department about how investigations should be conducted and about the value of and the principle of independence and impartiality in conducting those investigations, even when they end up leading you into politically sensitive areas. And so the special prosecutor is one possible way of dealing with these conflicts of interest, and historically it's been a fairly effective one, although not a universally effective one. But there are other institutions which exist to counteract these dangers, and one of those institutions or institutional mechanisms are the strong norms within the Justice Department and the strong culture of political independence in the Justice Department, which serves as some kind of protection against presidential interference, even in circumstances where the ordinary chain of command would seem to permit the president and his attorney general, you can think of as sort of the president's right-hand man in this context, interfering with these investigations.
And you mentioned early on when we started talking about this that ultimately the American people, in a sense, have a role here, which is that if they have if they have sufficient confidence and faith in the integrity of the prosecution, the way the investigation and prosecution is being handled, that does serve as a check on the president's ability to interfere, certainly to fire those prosecutors just because he doesn't like what they're doing. And it seems like that exists here as well with the federal prosecutors in New York. It would be an outrage of almost unimaginable dimensions if in light of what's already happened, the president's personal lawyer now going to jail and having it come into the public that he has directly implicated the president, it would be an outrage of inestimable proportions if President Trump now were to try to fire those prosecutors, take them off the job.
I think that's right. What a special prosecutor adds is a greater visibility and a greater degree of institutional independence. There definitely is a political check. At least once an investigation, like the campaign finance investigation of Michael Cohen, becomes public, it becomes much more difficult for the president to interfere, at least in ways that would be highly publicly visible. The problem is that the president has lots of tools at his disposal to interfere with the Justice Department's investigation behind the scenes. Some of those might come to light. You could imagine a U.S. attorney resigning or an assistant U.S. attorney resigning and publicly speaking out if the president, in fact, interfered in a way that they viewed as contrary to their ethical obligations as prosecutors to conduct an independent investigation. So there absolutely is a political check in that context. The political check is stronger when the president appoints a special outside prosecutor, and the ability of the president to interfere in those kinds of covert ways with a special prosecutor's investigation is more limited than it is in the context of an ordinary Justice Department investigation. Although even in the context of a special prosecutor investigation, the president and the attorney general do have some significant power to interfere with the investigation, to undermine the investigation behind the scenes in ways that it would be very hard for the public to hold them accountable for.
Okay, Andrew, I have two last sort of rule of law questions that I have to ask you, and we are building to these questions, I think, in as we now understand the way these special counsel investigations work. And that is, first of all, can a president, or can this president, be compelled to testify? There's been a lot of talk about President Trump submitting answers to written questions to Special Counsel Mueller, but a lot of resistance to the idea that he would actually offer actual testimony, a deposition, let's say. And secondly, can a president, or can this president, actually be indicted? Can the president be charged with a crime?
So let me take those questions in turn. Both of them are, in a formal sense, open questions. Neither the Supreme Court nor any other federal court has squarely addressed either of these questions at any point in American history. And that tells us something important, that historically neither the president nor parties investigating the president, special prosecutors, have been eager to press these questions to a final judicial resolution. They have preferred to resolve them through compromise and negotiation outside the court system. So I think that is likely to be the way that these questions get resolved in the present context as well, because I think both parties have significant incentives not to kind of go to the mat and push for a final judicial resolution of these questions. But with that said, the negotiations and the compromises that the president has historically reached with special prosecutors and that President Trump might reach with Mueller in this case are themselves influenced by the state of the law. They operate in the shadow of the law, as a law professor like me might say. There is some interesting law on point on the subject of the questions of the president's obligation to testify in court, or the president's susceptibility to a subpoena that would force him to give oral testimony. And the closest precedent on point here is the Supreme Court decision in United States versus Nixon, which was the case in which the Supreme Court ordered President Nixon to turn over secret White House tapes sought by the Watergate special prosecutors, whose disclosure ultimately forced Nixon's resignation. And in that case, the court said that the president does enjoy a kind of constitutional privilege akin to the attorney-client privilege, which guards the confidentiality of communications between lawyers and their clients. The president enjoys a similar privilege for communications with his own high-level advisors, and presumptively it is impermissible for a court to inquire into those communications or to require the president to provide evidence to a court involving those internal communications, because it's very important that they be kept secret in order to preserve candor and to protect the president's ability to get unvarnished advice from his close advisors. But in United States versus Nixon, the court said that that privilege is not unlimited, it's not absolute, and when evidence is necessary for a criminal prosecution, the president must make a kind of special showing. The president must, in other words, come up with a very specific and weighty reason for refusing to submit to the court's demand for evidence. There's a kind of general principle that the public has a right to every man's evidence, and that extends to the president, the Supreme Court says in U.S. versus Nixon, unless the president can give a special reason. Probably that special reason would have something to do with national security for withholding documents that were subpoenaed in a criminal investigation. So what does that mean for the present case? Robert Mueller is conducting a criminal investigation. If Robert Mueller seeks to serve a subpoena, a judicial order, on President Trump, compelling him to provide oral testimony to assist in that investigation, what does U.S. versus Nixon tell us about the president's obligations? It tells us the president does enjoy some kind of privilege based on the importance of his getting confidential advice, and probably also indirectly on the importance of his preserving the confidentiality of his own internal deliberations. But that privilege, that confidentiality that the president enjoys, and immunity from judicial process that the president enjoys, is not absolute, and that in a criminal investigation, presumptively the president is going to be required to provide evidence unless he can show one of two things. First, if he can give a specific and persuasive national security investigation for resisting testimony on a particular subject, then that would probably exempt him from the obligation to give oral testimony. Second, and this is an issue which Nixon did not directly involve, because Nixon involved a request for tapes, not a request for oral testimony on the president's part. The prosecutor is going to have to be sensitive to, and the court which orders President Trump's testimony is probably going to have to be sensitive to the unusual demands of the president's job and the importance of working around the president's schedule. Trump will argue, as presidents have historically, that it would be an impermissible burden or interference with the president's incredibly demanding and busy job for him to be required to sit down with prosecutors for a few hours to answer questions and to sit down with his own lawyers for probably several days to prepare for those questions. And so the prosecutor will have to show that he and the court will have to show that it is sensitive to the president's job responsibilities and to come up with some kind of schedule that will interfere with those job responsibilities in a minimal way. I think this is probably how a court faced with this question would apply Nixon in order to address this new question of whether the president can be compelled to give oral testimony. The big new issue that this raises is that oral testimony requires the president to be physically present and to personally invest and involve himself in preparing for questioning in a way that the disclosure of documents or the turning over of tapes did not. And so to that extent, it raises some new questions.
Well, but there's another Supreme Court case that ties in, right, which is the U.S. versus Clinton case where President Clinton did have to ultimately give a deposition form of testimony, but that was a civil case. That was the Paula Jones case, and that was a case involving conduct before Clinton became president. So wouldn't that make it more likely, at least in the Russia investigation, since there at least some portion of the conduct that's being looked into was conduct before Donald Trump became president, was when he was campaigning for president. And so wouldn't the standards...
The Clinton versus Jones case is relevant. It addresses technically a different question. So it would be easier for the court to completely distinguish it and to set it aside in resolving the question about whether President Trump could be compelled to testify. The question it addresses is whether the president is immune from civil suit during the term of his office, during his term in office. In other words, can the president be sued at all for conduct outside of his official job responsibilities while he's in office, or does that kind of a suit have to wait until the president leaves office? And in Clinton versus Jones, the court said, no, the suit can proceed while the president is in office. And once that suit proceeded, once Paula Jones' sexual harassment suit against Clinton proceeded, Clinton himself voluntarily agreed to provide testimony, both in that case and in Ken Starr's subsequent investigation of obstruction of justice and perjury in connection with the Monica Lewinsky affair.
So that issue never had to be litigated or decided by a court.
So that it never had to be litigated. And so I think it's quite important to be clear that the question of whether a suit can move forward against the president while he's in office is quite different, or is at least distinguishable from the question of whether the president could be compelled to give testimony in defending that suit. And so for that reason, I think Clinton versus Jones is less closely on point to this question than United States versus Nixon is, although it is at least arguably relevant.
Okay, so it seems likely then that since neither side, or no side, maybe there are more than two sides here, since no side really wants a hard and fast ruling on this question, can the president be compelled to give testimony in a criminal investigation in which he himself is implicated? And that would happen by taking the issue, pressing the issue to the Supreme Court, getting a ruling. Probably the Supreme Court itself doesn't even want to have to make that kind of a decision, I would think. It seems likely from what you're saying that pieces of all of these issues that have come before will help inform how these issues get negotiated and worked out, other than having to press them to court.
That is how it has worked in every previous case. We have a wild card in the present case, though, which is that the current president, Donald Trump, has made a career out of defying conventional wisdom and defying traditional political norms, and seems to relish a fight and seems to believe that he strengthens his support with his political base by demonstrating toughness and resolve in the face of opposition in a way that might potentially lead him to take a harder line than previous presidents have and to force the issue to some kind of ultimate judicial resolution, even if a more conventional president would be reluctant to push the matter that far.
Well, we're going to have to see about that. But what about the second question I posed, which is a big hot question right now, as the Mueller investigation seems to be reaching a climax and perhaps reaching its end. Now, Mueller's investigation has indicted and prosecuted and even achieved jail sentences in the case of a number of senior campaign officials and White House officials through his work, including the president's former campaign chairman, Manafort, and there may be other indictments that will drop in the coming weeks. But the president himself hasn't yet been indicted. And then, as we mentioned, there's this case still proceeding in the Southern District of New York, where his former personal lawyer, Michael Cohen, has been prosecuted, pled guilty, and received a jail sentence. But the president has not yet been indicted. So the question is, can he be indicted? Can a president be indicted, charged with the crime?
As I mentioned a moment ago, that question has never been resolved by any court. And there are respectable constitutional arguments on both sides. The strongest constitutional argument against the president's susceptibility to indictment is that impeachment is the exclusive constitutional means for removing a president from office, and that even though the Constitution doesn't explicitly grant the president immunity from indictment, the high threshold it establishes for impeachment makes clear that the framers of the Constitution thought it was unwise to remove a president from office except through a democratic process in which the people's representatives were actively involved and where there was a strong consensus democratically that the president should be removed. And that this implies that the president should not be subject to indictment and certainly not subject to incarceration during his term of office, because that would in effect disable his ability to perform his duties, even if he would formally remain the president, and subvert the constitutional design, which makes impeachment the exclusive method for removing the president. The strongest argument for allowing the president to be indicted while he's in office is this basic principle, which is, again, nowhere expressed in the Constitution, but at least implicit in the constitutional design, and was certainly one that was broadly embraced at the time of the founding, which is that no one, not even the president, is above the law, and that if the president commits a crime, or if there's credible evidence that the president commits a crime, then he should be subject to indictment like anybody else. Ultimately, the constitutional question, I think, is very unlikely to be litigated in this case, just as it has never been litigated before, and that is because there is an internal Justice Department policy, twice reaffirmed by the Office of Legal Counsel, which takes the position that the president cannot constitutionally be indicted, and that policy is almost certainly binding on Special Counsel Robert Mueller, and thus Mueller himself is extremely unlikely to indict the president. That policy is also binding on the U.S. Attorney's Office for the Southern District of New York, so I think we're unlikely to see the president indicted, at least during his term of office, by that U.S. Attorney's Office either.
And indeed, in the Clinton case, Ken Starr did not indict President Clinton, but instead submitted a report which recommended that Congress take up, after presenting all the evidence that he developed during his investigation, Starr recommended different crimes or alleged crimes that Congress could take up in the form of impeachment, and then that is in fact what they did, ultimately unsuccessfully. But that seems like a route that we could see more as a more likely outcome than that Mueller, as special counsel, would indict Trump, that he would generate some kind of a report in which he would recommend what Congress might take up in the form of articles of impeachment.
That's right, although the situation is a little bit more complicated today than it was at the time that Ken Starr wrapped up his investigation, because Robert Mueller is operating under the new set of special counsel regulations adopted in 2000 and not under the Independent Counsel Statute, the Ethics in Government Act, which governed Ken Starr's investigation. And under the new regulations, at the termination of his investigation, the special counsel is obligated to submit a report, but that report is confidential, and it is submitted to the Attorney General rather than to Congress. And so assuming that this plays out according to the regulations, the end game for Mueller's investigation follows the script set forth in those 2000 regulations, then what we are likely to see is the submission of some kind of confidential report to the Attorney General. My guess is that that report will much more closely resemble the report submitted to Congress by the Watergate investigators than it will Ken Starr's report. The Watergate report simply laid out the evidence against President Nixon without offering any kind of formal recommendation or laying out any kind of formal charges. And I think Mueller is likely to follow that model rather than Ken Starr's model of actually recommending impeachment and putting forth formal charges. But regardless, according to the regulations, the person to whom that report will be submitted confidentially at the end of Mueller's investigation is the Attorney General. Today that would be Acting Attorney General Matthew Whitaker. In a few months it might be President Trump's new Attorney General nominee, William Barr, assuming that he's confirmed by the Senate. And at that point it would be up to the Attorney General whether to disclose to the public or whether to disclose to Congress some or all of the contents of Mueller's report. I think there will be a lot of political pressure on the Justice Department, on the Attorney General, to at least make that report available in full to Congress. But the extent to which the Attorney General feels compelled to bow to that pressure, especially if the report is highly damaging, I think is an open question. It'll be very interesting to see how that plays out. With all of this said, Robert Mueller does have a variety of other ways of getting the results of his investigation out into public view. One way that he's been using so far, at least in a piecemeal fashion, to do just that is through the use of what are called speaking indictments and other court filings, in which when you file an indictment against somebody like Paul Manafort or someone like Michael Cohen, he does so in a way that includes much more information than would be formally required in those court filings, as a way of making some of that information available to the public. Some of that information remains under seal in various courts around the country, but at least by filing that information with the court, he ensures that it is part of a public record, which is outside the control of the executive branch. And I think most observers believe that Robert Mueller has been following this course quite strategically, quite self-consciously, to guard against the possibility that the Justice Department might shut down his investigation under pressure from the president at some point.
Well, and as you say, that seems like they're, especially in this environment, and you've got on this day that we're recording this episode of the program, the Democrats officially taking control of the House of Representatives. It does seem like it would be, very difficult politically for Mueller to submit a report to the Attorney General and have the Attorney General not release that report to Congress. But that brings us full circle back to something you said at the beginning, and I want to wrap up with this idea and give you a chance to speak to this for a moment, which is, we've talked about prosecutors and the president and Congress, but we haven't talked much about the American people. What do you think in all of this that the American people, that us ordinary American citizens need to know and do about these issues, and maybe put it into the present context, since that's what's most immediately in front of us?
Well, I really think that the most important thing to keep in mind is that everyone, Democrat or Republican, everyone has a profound interest in maintaining the sanctity of the principle that no one, not even the president, is above the law. At any given time, this principle is likely to seem like it has partisan implications, and it certainly does in the present context. People who like President Trump are likely to be skeptical of Mueller's investigation because it threatens him, and people who dislike President Trump are likely to be supportive of that investigation for the very same reason. But the ability of the American constitutional democracy to remain a kind of going concern over time is really dependent on the American people's willingness and ability to set aside partisanship and at least when the president is credibly accused of breaking the law, and to examine the issue impartially and to demonstrate their commitment to this principle that no one, not even the president, is above the law. And as a practical matter, the American people have already, I think, made a strong statement in support of that principle in the midterm elections. The Democratic House of Representatives is likely to conduct a much more robust investigation of the president, is likely to amplify the results of Mueller's investigation in important ways. But the next 2 years will pose a real test of American democracy, and During that time, I think the American people will have a decision. How vigilant are they going to be about maintaining the principle that no one, not even the president, is above the law, and to what extent is that principle going to inform their vote in 2020? And at the end of the day, I think that is where Mueller's investigation is ultimately leading us. It's possible that we'll see some kind of impeachment process initiated before then. It's possible that Mueller's investigation will make public evidence that produces a kind of broad popular consensus that impeachment is appropriate. But short of that, the next opportunity for the American people to hold the president accountable is at the ballot box in 2020. And Robert Mueller's role is to keep the president's alleged misconduct central to public attention and to provide the public with the information it needs to make an intelligent judgment about that conduct.
Well, it is going to be, as you say, an important and fascinating next couple of years. And this has been a really fascinating last hour or so. Andrew Coan, as of when we air this episode, your book will have just gone on sale. And again, so people know, it is called Prosecuting the President: How Special Prosecutors Hold Presidents Accountable and Protect the Rule of Law. It's being published by Oxford University Press. I have read an advanced copy of the book. It's really excellent, fascinating, great stories, incredibly important information that will help everybody understand not only the history, but even more importantly, what's going on today. And we'll put up a link so that people have the ability to get information about the book and get access to buying the book. Andrew Coan, a constitutional law professor at the University of Arizona Law School. Thank you so much for being on Good Law, Bad Law. It's been great. I really appreciate it.
Thanks so much for having me, Aaron.